Mediation is a process where a professionally trained mediator will help a separated couple discuss financial and/or child arrangements as part of the mediation process. The mediator is even-handed and neutral and is there to help both people. And the mediation process will start off by the mediator having an individual meeting with each person where they can find out more about mediation and the other options to resolve matters, and also the mediator can assess whether mediation is suitable. If mediation is suitable, and if after each initial meeting both people want to go ahead with mediation, then joint sessions can be arranged. And at joint sessions, with the help of the mediator will facilitate conversations and discussions so that the separated couple can come up with solutions and proposals to their specific set of circumstances. The timeline of mediation really does depend on what is being discussed at mediation, so whether that's financial matters and children matters or both. Generally speaking, you could have between 3 to 5 joint sessions after the first initial meetings. So that could take around, say, anywhere between 6 to 12 weeks, depending upon the gaps between the mediation joint sessions. One of the really good things about mediation is that actually the timeline is for the individuals in the mediation process to decide. So if they're keen to get on with matters, they can have shorter timescales between their joint sessions, or actually if they want to take matters at a bit of a steadier pace, or they've got some information gathering to go and do in between sessions, then they can have a bit of a longer gap between their sessions. So one of the key ones that springs to mind is cost. So mediation is significantly more cost effective than legal representation in court proceedings. Mediation is also a voluntary choice, so both people have to want to go to mediation, and that is in comparison again to a court process where somebody might find themselves in court proceedings that they didn't want to be in because the other person had made an application to court. Another really good thing about mediation is timescales. So again, in a court process, you could be waiting several to many months for a court hearing, or the court may set deadlines for documents that are actually really inconvenient for you or don't work with your timescales. Again, because mediation is a tailor-made process and the two individuals have to decide when their next joint sessions will be, they can control the timeline and they can control when the joint sessions will happen. In terms of choice as well and having decision-making power in a mediation process, if you're in court proceedings, eventually at the conclusion of those proceedings, if an agreement isn't reached, a judge or some magistrates will make a decision in your case and take that decision away from you as the individuals to make it. That is in comparison to mediation, where the mediator doesn't make decisions for you. The decision making and solution building and proposals that you're discussing at mediation is all down to the separated couple and for them to decide. Another really good thing about mediation is that it can improve communication. So at the end of a relationship, communication can become fraught and may have deteriorated, and mediation can be really good for improving that, and that can be particularly beneficial for separated parents because they're going to need to communicate moving forwards for their children, which is not only good for them practically day to day to be able to communicate effectively, but also of course for their children or their child to see that they can actually communicate. That can be really beneficial. No, proposals discussed at mediation are not legally binding. However, if both people want to proceed with those proposals after the mediation process, then they can speak to their respective solicitors, and these solicitors can help draw up a draft court order which reflects the proposals that have been discussed. And then if both people sign that court order, it gets submitted to court and a judge approves it, then you have a legally binding order. This is why it can be really helpful and is often highly recommended to get legal advice in the background too and alongside the mediation process, so that you can speak to your solicitor and get legal advice as you're going along about the various options and proposals that are being discussed at mediation.